As a founding member of the bipartisan Mayors Against Illegal Guns, co-chaired by Mayor Menino of Boston and Mayor Bloomberg of New York, I rise today in strong opposition to the National Right to Carry Reciprocity Act. This dangerous legislation threatens public safety by undermining the ability of states and localities to reduce gun violence by limiting the carrying of loaded, concealed weapons within their borders. This bill has nothing to do with honoring the Second Amendment, but instead completely dishonors the rights of local communities and state governments to make decisions to protect the well-being and safety of their citizens. This bill prevents states from responding to the unique needs of their communities as they determine the eligibility criteria for carrying a loaded, concealed weapon, and instead forces them to accept standards set in other states. As a result, this bill strips away reasonable limitations properly enacted by states and imposes upon every state except Illinois the least restrictive standard in the country for carrying a concealed loaded gun. The implications of this bill are drastic and a radical departure from well-settled practice and law that assigns primary responsibility for public safety to states and localities. In Rhode Island and in many states like it, this bill would decimate the strong concealed carry framework developed by duly elected officials within the state. These officials enacted requirements that they believe most effectively prevent dangerous individuals from carrying a concealed firearm within their borders. Rhode Island does not have any reciprocity agreements recognizing any other state permits, and our heightened standards require applicants to be at least 21 years old, of good character, not an abuser of alcohol, to complete a firearms safety training course that includes live fire examination, and to show good cause for needing a concealed carry permit. To further provide for our unique public safety needs, Rhode Island also grants broad discretion to local law enforcement officials in the process of approving or denying a concealed carry permit. As a result, Rhode Island ranks among the states with the lowest gun death rates, less than half the national average. Under this bill, Rhode Island would be forced to recognize concealed carry permits from all states, regardless of how lax the other states' standards. This would leave my fellow Rhode Islanders subject to the whims of other states' concealed carry permits, and actually prioritize the rights of out-of-state concealed carry permit holders over the rights of Rhode Islanders within our own borders. For example, while Rhode Island requires safety training that includes a live fire exam in order to acquire a concealed carry permit, there are 10 states that have no training requirements whatsoever. While Rhode Island prevents alcohol abusers from obtaining these permits, only 28 states have such a standard in place. The common sense provisions of Rhode Island state law and the laws of similarly situated states prevent dangerous individuals from carrying loaded, concealed weapons. Such protections would be completely undermined by this law. This bill is a clear and undeniable threat to public safety and will facilitate a new path that allows more and potentially dangerous individuals to carry concealed loaded guns within our borders and against our will. This must not be allowed. Because this bill presents such an indisputable threat to public safety in many states, I've introduced this amendment, which would require that at the very least, prior to granting reciprocity in a state, the Attorney General, the head of the state police, and the Secretary of State jointly certify that the laws of a non-resident permit holder state are substantially similar to its own. This would provide states an opportunity to preserve adherence to its core requirements that restrict concealed carrying weapons, but not allow them to deny permits from states that match its standards. It would at a minimum ensure that we respect the decisions and judgments made by local and state governments on this key public safety issue. The certification process will not be burdensome to states. In fact, some states, including South Dakota and Nebraska, already incorporate this type of process in determining eligibility for engaging in reciprocity agreements with other states. I urge my colleagues to support my amendment and protect the citizens of this country from the imposition of dangerously lax standards for the carrying of concealed weapons in direct contradiction to the decision of local and state governments charged with protecting the lives and safety of their citizens. I reserve the balance of my time.